Dispute settlement in international trade made simple. 4 key mechanisms. When goods cross borders, risks follow. A late shipment, an unpaid invoice, or a disagreement over product quality, or any of these can quickly turn into a costly dispute. That's why understanding how disputes are settled in international trade is crucial. In today's video, we will break down the key mechanisms of dispute settlement: negotiation, mediation, arbitration, and litigation in a simple and practical way. Why dispute settlement matters? International trade involves multiple countries, different legal systems, and diverse business cultures. When a dispute arises, it can disrupt supply chains, damage reputations, and lead to huge financial losses. So understanding how to resolve disputes isn't just legal knowledge, it's a business survival skill. The 4 key mechanisms explained simply. Negotiation. Negotiation is the simplest and most common way to settle disputes. The parties talk directly without a third party. It's fast, inexpensive, and relationship-friendly. But here is the catch: there is no legal guarantee. It only works if both sides are willing to compromise. That's why negotiation is always the first step before taking things further. Mediation. Mediation brings in a neutral third party, the mediator, to help both sides reach a voluntary agreement. The mediator doesn't decide, it guides communication. It's confidential, less confrontational, and cheaper than arbitration or court. The downside? It only works if both parties agree to join. It's not legally binding unless put in writing. Arbitration. Arbitration is the leading mechanism in international trade in our opinion. It's binding, neutral, and enforceable in over 170 countries under the New York Convention. Businesses can choose their arbitrators, language, and place on the seat, leaving flexibility and expertise. However, arbitration requires a written arbitration clause in a contract. You cannot arbitrate later unless both sides agree. Litigation. Litigation means taking the dispute to a national court. It's often used when there is no arbitration clause, but litigation is slow, costly, and hard to enforce internationally. A company might win in its home country but fail to collect money abroad because enforcement is limited. When mediation and arbitration mechanisms combine. In real life, mediation and arbitration methods can combine. Some contracts require mediation first, and if it fails, then arbitration. This hybrid is called Med Arb, offering both flexibility and enforceability. It's an evolving practice, but counsel in arbitration must be cautious about neutrality. The same person acts as both mediator and arbitrator. In conclusion, the 4 main mechanisms, negotiation, mediation, arbitration, and litigation, form the backbone of dispute settlement in international trade. Each has strengths and weaknesses, and the right choice depends on cost, enforceability, and above all, what the contract allows. If you find this video helpful, don't forget to like, subscribe, and share for more insights on international trade and dispute resolution. Thank you for tuning in.